Hello, and welcome to our Managing Public Records mini-series. Over the course of the next three videos, we'll be answering some common questions about managing public records. Let's start out with a quick overview of public records law in North Carolina. You may be thinking, what do I need to know about public records law? Well, as a government employee, it turns out that you need to know quite a bit. But first things first, what exactly is a public record? North Carolina General Statute 132-1 defines a public record as any record, regardless of format, that is created in the transaction of government business. This means that public records can be maps, text messages, documents, emails, photographs, videos, audio recordings, letters, and so much more. The law makes no distinction between personal and private devices. So if you are conducting government business on your personal device, that is still a public record and still subject to public records request. Which brings us to GS 132 6, the statute that outlines your responsibilities for public records request. According to this statute, records requests must be answered at reasonable times. This doesn't mean you have to come into your office at 3 a.m. to answer a records request, and it's pretty unlikely that you'll need to use a helicopter. However, they must be answered as promptly as possible. While the wording is vague to allow for the time it takes to handle records requests of different sizes, you shouldn't drag your heels when responding to public records requests. The statute includes additional stipulations regarding intention, fees, and confidentiality. Firstly, no one is required to give you a purpose or motive for the public records request. You're allowed to ask if you think it would help you fulfill the request, but they are not required to answer. Second, you cannot charge for the inspection of records. If copies are requested, fees must be limited to material cost. However, if the request meets the criteria of GS 132 6.2b, a special service charge may apply. Lastly, you cannot deny a records request on the grounds that there is confidential information included within the records. The agency must instead bear the cost of separating or redacting the confidential information. But what exactly counts as confidential information? In order for public records to be confidential in North Carolina, they must be made confidential by federal or state statute. That means that if you're trying to claim that a record is confidential, you must be able to point to the law that makes it so. Medical records, personnel files, prison records, student records, and blueprints for publicly owned buildings are some of the records that are confidential or contain confidential information. And according to General Statute 132 11, confidentiality for most records expire after 100 years. Now that we understand the basic principles of public records law, let's go over a few terms that will be useful to know as you move through the remainder of these modules. As we mentioned before, public records consist of records created during the transaction of public business. However, not all public records are necessarily created equal. Typically, records fall into one of three categories: record copies, reference copies, and transitory records. The record copy is a copy of a document, often the original, that is designated as the official copy for preservation. This is a copy that must be kept in accordance with the retention and disposition schedule, so it is important to designate the record copy of a document and its custodian. Reference copies, on the other hand, are duplicates of the record copy. They are made or kept for easy access to the information they contain. For example, if you print out an email, the email itself will be the record copy, and the printout will be a reference copy. Finally, transitory records are records that have little to no intrinsic or evidentiary value. They are typically destroyed immediately or only kept for a short period of time. Example of transitory records include routing slips, transmittal sheets, catalogs, fax cover sheets, and drafts of other documents. You may have heard me mention retention and disposition schedules when discussing record copies. We'll go into more detail in Module 2. But for now, just know that these schedules identify and describe an organization's records and tell you what to keep and for how long. Thank you so much for joining us on this short law adventure. We hope you enjoyed learning a little bit more about public records law in North Carolina. But before you go, we have one quick question for you. Which of the following is not a public record? Is it DNCR personnel files, local government payroll records, an email from a constituent, or a text message to a colleague about the concert you went to last night. That's right. A text message to a coworker about a concert you attended is not a public record. We'll see you next time as we take a closer look at retention and disposition schedules. For additional guidance and assistance with managing your public records, please visit our website, archives.ncdcr.gov/government.